Okay, just giving everyone a second for it all to catch up. All right, welcome everyone. Thank you for joining us for today's webinar with Harry Margolis and Jason Swadel as they take turns reviewing interesting law cases from the last year. My name's Beth Cohen-King. I'm the marketing director at Margolis, Bloom & D'Agostino. So the reason for this webinar is because it's important to know what's happened in the courts in the last year, as some of these situations may be applicable, as well as thinking about some of the pitfalls and what to avoid if you run into any of these situations. We all know family and MassHealth can be a little bit messy. We do, just in terms of housekeeping, we have a panel on the side of the screen that you can use to type in questions as they come up. And I will try to interrupt Harry and Jason if something's relevant in the moment. So if not, we'll also answer questions at the end. And anything we don't get to, I always send them the questions so they can follow up if it makes sense. And for some reason, if you need to jump off, we are recording the presentation. So no worries, and you will have that. It will be within the next week. It'll be on our website under the resources section, which, just by the way, you can find every webinar that we have produced on our website there. So lots of good content. And then I will send it out in the e-letter as well. So with that, Harry, I'm gonna let you take over.
Okay, thanks, Beth. So as Beth said, we're talking about cases that happened in Massachusetts over the last year or so. We call this the best law cases of 2023. I'm not sure if they're quite the best cases, but they're the most interesting and relevant to the practice of elder law and estate planning in Massachusetts. So let's see. There we go. So these are the cases we're going to go over, and we're going to do it as something of a tag team. So I'll start, and then Jason will go, and then I'll go, and so on and so forth. So so here we go. So the first case is in the matter of the estate of Ronald Birkenfeld, and Mr. Birkenfeld left his estate in trust for his wife Pamela, who is not his first wife, but a second, I believe, and with the remainder to his children, subject to Pamela's power of appointment, which meant that she could decide which of the children got the remainder interest, but only among Ronald's children. Ronald also named Pamela as personal representative of his estate and as trustee of the trust, along with an independent trustee. Ronald died in 2020, and this is it's left out a word here. And Bradley, Ronald's son, immediately sued Pamela for fraud related to a $500,000 gift that he had made to Ronald, and he apparently felt it was to pay off mortgage on the house, and it wasn't used that way, and he was very unhappy. And of note, Bradley could afford to sue and hire lawyers because he won a $104 million whistleblower award having to do with tax fraud, tax evasion, and UBS Bank. He also, and this is a little confusing to me, served 31 months in jail for fraud related to the same matter. So I don't know how he got a whistleblower award for perhaps blowing the whistle on fraud that he participated in. But anyways, it was probably a very interesting backstory there. So, so he sued to get Pamela removed as personal representative of his father's estate, and the question was whether he had standing to do that, because he was not a beneficiary under the will. He was a potential beneficiary under the trust, but he was specifically excluded under his father's will. So the question is whether someone who's not a beneficiary under a will can challenge the appointment of the personal representative. And So the Massachusetts Uniform Probate Code allows an interested person to file for the probate of an estate and also to challenge the admission of a will. But the question that's not clear is whether they can bring an action that like Bradley is doing here, to remove the personal representative, because there's two different issues. One is challenging the will, and the other is challenging the personal representative. And it turns out that at least the Massachusetts version of the Uniform Probate Code doesn't talk about challenges to the appointment of the personal representative. So the court says, well, if it's not in the statute, then we got to look at the common law, which is the centuries of court-created law, to see whether the person who's challenging the personal representative must have a legal interest in the estate, since Bradley didn't, because he was specifically disinherited. And so that's the question, and the court rules that under the common law, he could not challenge the personal representative. So it's interesting. So the conclusion is he can challenge the will, but once the will is admitted, he has no standing to challenge the appointment of the personal representative. This may be a relatively unusual situation in lots of ways, and an unusual finding, but does show how courts kind of parse the law. They look at the statute, and where the statute doesn't give an answer, they look at the common law, at least in the area of probate administration. So that's the Birkenfeld matter. And next, Jason is on MassHealth estate recovery.
All right, thanks, Harry. So the next case is in the matter of the estate of Francis R. Mason. So for background for this case, Francis Mason died in 2008 after receiving less than a year of MassHealth covered nursing home care. However, for whatever reason, her personal representative of her estate did not file for probate until 2017 and was appointed later in 2018. The personal representative sold Ms. Mason's home in 2021, holding the proceeds in escrow, pending the determination of MassHealth's claim for reimbursement of its costs for paying for her care. The next slide, please.
Any little trouble with that?
Oh.
There we go.
So then for some additional background, so there's the Massachusetts Uniform Probate Code, which took in effect in 2012, which was after Ms. Mason passed away, but before her personal representative filed to probate her estate. And the MUPC provides for a 3-year time limit on claims against estates. So then the issue that arises is whether the proceeds from the 2021 sale of the home could be subject to MassHealth estate recovery, because it's about 13 years after death and 9 years after the MUPC. And then the additional question is whether MassHealth's lien that they had on her property ends at her death. So ultimately, the SJC holds that the 3-year time limit is not retroactive. So since Ms. Mason died before the MUPC was enacted, whatever the law was at the time is what should be in effect for any estate recovery, which ended up being 50 years. So a big difference between 50 and 3. So it applies to cases pre-MUPC, the old law, but the post-MUPC is a 3-year time limit.
So yeah, so even though, yeah, I was going to say, so even though the estate sort of lost in this case because it was an older case and MassHealth could pursue its estate recovery claim, the court clarified that the 3-year statute does apply to them for any newer case. So if, which is interesting, because it's almost an incentive for people who have potential MassHealth claims not to probate the estate until the 3 years has run. And of course, MassHealth as a creditor can probate the estate, so they would have to get organized and do it. So we'll have to see what happens. you're going to add anything else there, Jason?
So yeah, I think there's another slide if you
Oh,
want
there is.
to
Oh, sorry.
go to that.
I got ahead. You're right.
Yep. So the estate did lose out regarding the 3-year time limit, but they didn't lose out fully in this case because there was MassHealth was also arguing that there's a lifetime lien on the home of Miss Mason, because there is a MassHealth rule that if a nursing home resident does not return home and chooses to sell their property, at that point MassHealth can recover from the proceeds it paid for the MassHealth recipient's care. In this case, Miss Mason never did return home, so MassHealth was arguing that the lien was still in effect and that it could collect on it after her death. However, the SJC does hold that any lifetime lien on a MassHealth beneficiary does end at death. So the estate kind of won in one way but lost in another way in this matter.
Right, and I'd argue they kind of lost in both ways because it's very, in terms of the clarification of the 3-year statute.
Yeah.
Okay, next case has to do with family protection trusts, and family protection trust is kind of a term of art that we use in our practice, and other people will use creditor protection trust, generation skipping trust, spendthrift trust. But basically, these are trusts that usually a parent sets up for the benefit of their children, and they're supposed to be structured in such a way that the assets in that trust are protected from the child's creditors and protected if the child got sued for any reason, and would also be also keeps the property in the family. So if the child dies, it governs where it goes. And what's pertinent to this case is that also protects the assets if the child gets divorced. So in this case, Juliana and Dylan Jones married in 1998, and they divorced about 20 years later in 2019. Juliana's mother had created a trust for her, for Juliana, which the Juliana Jones Irrevocable Trust, JJIT, and it included a typical spendthrift provision, but it was a little unusual in this trust because it said that the spendthrift provision, which said that the money that Juliana could not control the money, was only in effect during her mother's life. And when her mother died, and presumably it appears that she was still alive at this point, the trust, when she dies, the trust property was to be distributed to Juliana. So at some point, she would get the money not subject to the trust. So, anyways, as I said, or implied, it's been a long time law that a third party can create one of these trusts. But one of the rules for it to be protective is that it has to be totally discretionary, that the beneficiary can't demand payment, and the trustee is not obligated to make the payment. And so the question is, in this particular trust, whether it met those requirements so that the funds in the trust would not be part of the marital estate in the divorce and the division of assets. And so the probate court rules that because the funds were ultimately going to be distributed to Juliana at her mother's death, that it should be included in the marital estate, and some of it, I'm not sure what portion, but some portion would go to her husband. And so she appealed that. And so that's the question before the court on appeal. And she argues, so Juliana argues, that even though the money was going to come to her, there was another unusual feature of the trust, which said that it could be withheld for a compelling reason. And the compelling reason was defined as serious disability, drug or alcohol abuse, failure to enter into a prenup, which apparently she should have done, the possibility of divorce, the failure to pursue a college education or a vocation commensurate with her ability, and potential or pending creditor claims. So the mom seemed to want to have her cake and eat it too, or maybe Juliana did, that she would get her money unless there was something that threatened the trust assets. And the probate court agreed with the appeals court agreed with the probate court and didn't go with this argument, saying that while there was this effort sort of to recapture the trust and protect it, it was really only a postponement. One, it was very narrow. It was only if these particular things occurred, but it was also a postponement of the distribution, that ultimately the trustee would have to distribute the money to Juliana. And it wasn't just a normal creditor protection trust, which just gives trustee total discretion. So what they said is that while the trustee does have the power to postpone the wife's enjoyment and possession of the mandatory distribution pursuant to this postponement provision, the trustee does not have the power to divest the wife of her interest in the trust corpus. Even if the trustee is permitted to postpone the mandatory distribution indefinitely for the wife's entire lifetime, his power is limited to determining the timing of the mandatory distribution, but not the wife's ultimate entitlement to it. So basically, since ultimately she's going to get it, and they're going to include it in the marital estate. So I think the moral of this story is, don't try to get too fancy. Keep it simple. If you're trying to create a creditor protection trust or divorce protection trust, make it subject to the make it lifetime. Don't say that at some point that the funds are going to be distributed to the beneficiary, and give the trustee full discretion. Next one's yours, Jason.
All right. So next one is James Wad-Gianni et al. V. Nina Pare. So for background for this case, 2004, Leonard and Helen Wad-Gianni deed their home to their 3 children, James, Anne, and Nina, reserving a life estate for themselves. So as some background, so a life estate is basically a way of deeding a property where the life tenants get to remain on the property and have access to it. But then in this case, James, Anne, and Nina are the remainder beneficiaries. So upon the passing of the survivor of Leonard and Helen, the 3 children would inherit the property. So Leonard and Helen continue living in the house along with a 4th children of theirs, John, who had developmental disabilities. Helen ultimately dies in 2007. And then in 2011, Nina moves in to the property with Leonard and John in order to assist caring for them. However, the issue there is Nina was a hoarder. So James tries to get Nina to clean up the mess and doesn't really work out. By 2016, the sanitation department's involved and issues several violation notices. In 2018, Leonard and John eventually move out, and the property is or they obtain a no trespass order against Nina for the property. And then following that, the next comes up in 2019, James and Anne filed for partition, which is the right of any owner of property to seek a court order that it be sold and the proceeds divvied up according to each owner's interest in the property, which in this case is thirds for the 3 children. The partition is ultimately granted, and the property is sold in 2020. However, unfortunately, Leonard dies the day after the sale. So then the issue with this matter is, how should the sale proceeds be distributed? So there's the partition for thirds for the 3 children, but James and Anne want to charge Nina for the damage she's caused to the property as a result of her hoarding and the expenses that they had to pay to clean it up. So yeah, so there's some more info for life estate. So basically, yeah, the remainder men in this case are the 3 children. And they all have a property interest. And ultimately, the probate court rules that Leonard, as life tenant, had exclusive right to possession of the property and thus was the sole person who had the duty to preserve and protect the property. So while James and Ann don't have a claim against Nina, they have a claim against Leonard's estate. Case gets appealed. Appeals court rules that a life tenant may actually be liable for waste of property, but there's an exception when the remainder men themselves cause the damage, meaning in this case, since Nina was the hoarder and caused the damage to the property, she had a duty not to impair the interests of her two other siblings. So the case ultimately gets remanded to the probate court in order to determine the damages that Nina should have to pay, as well as whether James and Ann are entitled to attorney fees. So ultimately, I guess the main point of the case is that even though remainder men don't have, they aren't in charge of the property during the lives of the life tenant, they still have a duty not to cause damage to the property and to harm the interests of the other property holders.
Okay. Yeah. So play fair with your co-owners, I think is the moral. So next we have a trustee removal case, and it's in some ways similar to the other case, and kind of what governs the that was the MUPC and or common law. In this case, the question is which governs the trust or trust law, and so it involves the estate of Leo Kahn or his revocable trust. He was very successful. He had started 2 health food chains, both of which he sold to Whole Foods, and with some of that money was an early investor in Staples. He died in 2011, leaving a trust for his wife, Emily. Again, it's a second marriage, and Emily's stepson was a co-trustee with her. I guess that didn't work so well. So she tried to remove him according to a particular section of the MUTC, and the section 706B4 has a number of grounds for which you can remove a trustee, one of which is if all the beneficiaries agree, or all the qualified beneficiaries. And qualified beneficiaries are the beneficiaries with a current interest in the trust. So she tried to remove him. Joseph argued that no, he shouldn't be removed because under the trust instrument, trustees can only be removed for a cause. And the court agreed with Joseph and dismissed the suit, and Emily appealed it. So the question is, which governs the trust or the trust law? It's a little more complicated here because the trust here lists 12 reasons that a trustee could be removed for cause. It's a little unusual in that way. And then it included a 13th, I guess it's an unlucky number, and said that for any other reason for which a state court of competent jurisdiction would remove a trustee. And so the problem here is that then bring back in the MUTC, because even without these 4 cause reasons there in the trust, that seems to say, well, you can remove a trustee for anything that the trust says plus anything that the MUTC says. And the court basically punted on this and said, we don't know what Leo had in mind, and that's a question of fact, not a question of law. And when cases are dismissed, if there's they shouldn't be dismissed if there's a question of fact to be determined. So in this case, the question of fact is, what did Leo intend? And so the court remands this case back to the probate court to figure that out. Now, I don't know how they're going to figure it out, except maybe testimony of the attorney who drafted the trust. But maybe there will be future proceedings on this, and we'll find out the answer perhaps next year. Okay, Jason.
So next case is Schwalm v. Schwalm, which is another second marriage case. which tends to be a theme. And then so in 2018, William Schwalm creates the William Schwalm Retirement Plan Trust, naming his wife, Karen, as trustee and as beneficiary after his death. His children from a prior marriage are named as the remainder beneficiaries upon Karen's passing. William dies a year later, and his children subsequently ask Karen for a bunch of information about the trust. Karen declines to provide this information, and the children go to court seeking a court order that Karen provides them with all the information they request. Then the issue becomes, what duty does a trustee have to keep beneficiaries informed? So Karen's the trustee, and the trust provides that the trustee has the sole and absolute discretion to provide any information to a permissible distributee or qualified beneficiary, and may exclude any information that she determines is not directly applicable to the beneficiary receiving the information. This kind of hurts the children's case because under the MUTC, they're not qualified beneficiaries since they have no current rights to distribution. They only become qualified beneficiaries upon Karen's passing. Case gets appealed. Appeals court affirms the probate court's decision that the children are not qualified beneficiaries under the MUTC, and additionally, they're not entitled to trust accountings under common law. They find that Karen has the duty to keep accounts and records, but that's not tantamount to providing records in any specific accountings to the children as remainder beneficiaries. So children end up losing out. Karen doesn't have to provide them information. And I guess the main takeaway from this case should be that if you're the grantor and you want the remainder beneficiaries to have rights to accounts and other trust information, you should say so in the trust. You should be explicit, because otherwise there's no guarantee they get it.
Right. So a lot of questions, as Jason said, a theme of second marriages here, how to balance the interests and the control of your second spouse who you want to take care of and your children who you want to take care of. And those can be difficult and delicate relationships, unfortunately. Okay, back from that to back to MassHealth. So this involves whether MassHealth needs to be named as the remainder beneficiary on spousal annuities. So spousal annuities have long been planning techniques for community spouses of nursing home residents, for spouses of nursing home residents who are called in the statute community spouses. And they're limited to about 150,000 in countable assets other than the house. And so what a lot of people do is take the excess assets and turn it into an income stream by buying an immediate annuity. And that's a contract with an insurance company where they say, you give us $200,000 and we'll pay you $1,000 a month for the rest of your life, or whatever the numbers work out. Often it's accelerated so that rather than saying it's for life, it's for a particular number of years in order that the community spouse can get the money back sooner rather than later. And this case turns out to be even more of an incentive to do that. So the question is, what happens if the community spouse dies? I guess in two possible situations, but this was one in particular. But if the community spouse dies before the annuity has fully paid back what is due under it, and in one situation, the nursing home spouse might still be alive and receiving benefits, and the nursing home spouse might have already died. And this is the first case. So Joan Hamill moved to a nursing home in May of 2015, and her husband, Robert, purchased an annuity, and it listed Commonwealth of Massachusetts to the extent of benefits paid. And that's because the Massachusetts has been requiring that be put in there as the name of the contingent beneficiary, or the I guess, the primary beneficiary at his death, and then named his daughter as the contingent beneficiary after MassHealth. So Robert then died in 2016, and in 2017, MassHealth made a claim for payment for the benefits that it paid for Joan's care up until then. The annuity company, the insurance company, paid the balance of the contract to MassHealth, and Lori made this claim that against MassHealth, against the state, saying, well, they shouldn't have been paid. They had no right to that money. So, so that's the question. Does MassHealth have the right to these payments? And federal Medicaid law provides that in order to qualify as basically an annuity that works for sheltering assets, the state must be named as a beneficiary to the extent of benefits paid on behalf of the institutionalized individual, which has always been a little bit of a question about whether, I mean, it's clearly true if, say, Joan in this case had bought the annuity for her own benefit, but whether if community spouse buys the kind of what's meant by individual, because if the spouse, Robert in this case, buys an annuity for his own benefit, is he the individual, and is he only supposed to pay back if he's institutionalized? I think the weight of opinion is that it doesn't matter who's institutionalized, you got to pay back the state. But Lori makes a somewhat different argument. She citing a different provision of the federal Medicaid law. She argues that that this basically is an exempt transfer of assets when you're buying the annuity, because it was for the sole benefit of her father who was making the transfer. But the SJC disagrees, saying that if we're trying to kind of mesh these two rules in the federal law, the sole benefit rule, and it reads it as applicable to asset transfers generally, and not to the purchase of annuities, because there's a whole other set of law with respect to annuities. So as far as the SJC concerned, MassHealth is the rightful beneficiary of the spousal annuities. So so there's still, I think, a good planning technique. There's still an important planning technique for spouses of nursing home residents, but they just should try to make sure that they live out the term of the annuity. So so annuities can be for even relatively short periods of time, but they have to but they have to work. So you have to get back what you paid into it. And since the insurance company needs to make money, it can't be so short that the annuity company is going to not pay you back what you paid in, because they need to make their profit. So, but if you can, but you want to get the shortest annuity you can in order to minimize the risk that you're going to outlive it, and or not outlive it. That you're going to minimize risk that you're not going to outlive it and have to have some of the proceeds go to MassHealth. Unless, of course, you want to support MassHealth, which is not the end of the world, since they're also paying for your spouse's care. Next is yours, Jason.
All right. So this case is estate of Jablonski. So for background, Teresa Jablonski, she doesn't have a spouse, no kids, no parents alive. So she executes a will that leaving her entire estate to a testamentary trust for the benefit of her 15-year-old dog named Licorice, or any other pet that she might have at the time of her death. So for some background, testamentary trust is basically just a subtrust under your will that we see a lot of times for long-term care planning purposes, but you could also use it for pet trusts, which Teresa did. So upon the testamentary trust holds that upon Licorice's death, the balance of the funds go to charity. However, Teresa dies, and Licorice had predeceased her, so and she has no other pets, so the testamentary trust is never established. And then because the testamentary trust fails and the charitable remainder provision in the testamentary trust, as a result, also failed, some of Teresa's heirs, some distant nieces and nephews, they bring a claim, arguing that since the only bequest in the will lapsed, the entire estate must pass through intestacy, which then would result in the nieces and nephews getting the money. So the question then becomes, how should this will be interpreted, given that it's pretty unclear? And so basically the testamentary trust fails and results in property going to a residuary clause in the will, but the residuary clause provides that all the funds go to the testamentary trust, so which has also failed, so it just kind of goes back and forth. There's no clear indication where this money should go. So the case goes to probate court, and the probate court finds that Teresa intended for the charitable remainder to take effect regardless of whether her dog survived her. They kind of find this because there's a lack of intent for the charitable condition to only take place if the dog survived her. Nieces and nephews appeal. SJC eventually overturns the probate court and remands the case for further proceedings regarding intent. They basically just want to see more info regarding whether or not she wanted the money to go to charity. So the takeaway is basically just, you need to be clear in your will. If you intend for a remainder provision in the testamentary trust to be the ultimate disposition of property, you should make it clear and not draft the will in a way that theoretically the testamentary trust could fail and all your other provisions of the will fail as a result.
Yeah, it's pretty interesting because it could have been, might have just been a word or two in there, because because probably it sounds like the trust said, if Licorice survives me, or if I own any other pets at my death. So it's this if clause, then everything goes to the testamentary trust. And the drafter didn't think about, well, what happens if in the other circumstance where since you have an if, then you have to provide for what happens if that doesn't occur. I mean, my guess is that she wanted everything to go to these charities because if she wanted the money to go to her nieces and nephews, she could have easily said that.
Yeah, that'd be my guess as well, because it doesn't make sense why the charitable provision would only be contingent on a pet surviving her.
Yeah.
I think it's probably, just whoever drafted the will, there was a mistake or two.
Yeah, so it's a good lesson for all of us drafters. So that's all the cases we have this year, and it's we had some interesting themes in second marriages and some interesting MassHealth cases. I don't know if there are any questions, Beth.
I need to be off mute. No questions came in. So if anybody wants to throw anything in now, if not, you can always follow up with us as well. And you can see Jason's email is there, so he can field additional questions. But thank you guys. This was super interesting. I know some of these can get a little complicated as well. So when the recording is available, it'll be in our e-letter next week, as well as under the resource section on our website. And I think with that, thank you everyone for attending. Have a good day.
Thank you all.
Okay.
Thank you.
Good afternoon. Keep dry.
Yes. All right. Take care.